review. Point 3, advisory.
The one with no intra-court appeal.
Directly or indirectly, disguised or not.
Yes.
Number 2, no 143, not a substitute for review.
That already
And
Gopal has
review admittedly not filed in this case. Not filed. Number 3, 143, not a substitute for hurrah and curative. And no curative obviously filed in this case. Number 4, if my lord will turn to page 5 to save time of my written submissions, 5 and 6 have an issue-wise delineation of each issue raised in the reference, which para of the division bench decides this. This is extremely important. Lordship will pardon me for saving time, and I'm not taking your lordship may test it by going to any one para. For example, issue number 1, para 434.1, 434.2, 434.7. Directly deal with it in the conclusions. The reasoning is in the earlier paras 180, 185, 187, 189, 194, etc. Just because I don't have time to read them, please assume in my favor that they deal with it exactly. Every issue, barring issues 11, 12 and 14. Barring 11, 12 and 14, everything is directly covered. Now a word on these 3 issues when I come to the nuance then. 11, 12 and 14 do not really arise because 11, if your lordship will see the issues, is not a standalone issue and the others are peripheral issues. 12 and 14, in fact, not decided because it didn't really arise. They applied the Punjab judgment in the division bench. So substantially every issue para-wise is covered. Now, the nuance. Kaveri is clearly on point in my favor. But a nuance is added by 2G. Naturally, these 2 judges, lordship will spend 5 minutes on, otherwise lordship will not get a complete picture. Now, my learned friends will rely on parts of 2G, so let me give you lordship the point, which is also my lord chief's query, and then read those parts. What happens is, if a bench is hearing a matter, if it decides to refer by taking a view on 145.3, it can refer, no problem. If this bench decides the matter and chooses not to refer despite a submission in para 34L by him, then in an appropriate subsequent case, unrelated to this case, unrelated to the list between parties A and B in this case, in a matter between C and D in a subsequent case, your lordship may or may not refer the issue, not the list. However, the A and B decision, where it is not referred, cannot be touched by a so-called advisory view of 143, because that would be subversive of every principle your lordship follows. Now another nuance. That is what this 2G made, very fine nuance. 2G says that you can have a different view on the law, which is what my Lord the Chief Justice is asking. So in a C versus D case, the law may change because your lordship takes a different view. But same 2G mentions that you will not change the list of the decision between A and B in the first case, even by changing the law subsequently. Now another nuance, very important. In the present case, if your lordships allows this the advisory to proceed, your lordship cannot give, even if your lordship wants, your lordships cannot give a judgment. Assume your lordship allows the advisory, that the A and B, which is Tamil Nadu, A and B in this case is Tamil Nadu, stands as it is, and the law for the rest of the country will be C and D. Here, the nuance, that is one of the 2 words used in 2G, is view of the law and the decision in the case. So decision of the case, 2G Kaveri 5 judges say, cannot be changed. The view of the law can be changed in a subsequent order. Unfortunately or fortunately, in my Tamil Nadu case, if your lordship is persuaded to take a different view in 143, both the decision in Tamil Nadu changes and the view of the law changes, which is not permissible. Now come to all of those 2 judgments. Come to Kaveri first. This is the fastest I can do it, but I'll be very fast. 5.1 5.14 is the volume. 5417 is the case. Please keep these 8 principles in mind, Malas, because this is important when your lordship reads this to judge. Otherwise, Malas, these are repercussions. Your lordships is being asked, and let's be very clear about it, without any camouflage disguise, to change the decision, the merits of the decision, the content of the decision between A and B. And not in a subsequent decision, because there is no way your lordships can change the decision in a subsequent decision without affecting this decision of Tamil Nadu. So it's purely appellate, howsoever nicely you may couch it to a 143 court. And that's a very serious, fellows, subversion of Supreme Court discipline, Supreme Court integrity, Supreme Court institutional integrity. These are not rules made just like that. Your lordship has so many of, suppose this is wrong. In an appropriate case, your lordship may refer it. A constitutional bench may sit. But the law will not change for the parties who took it to the other division bench. Because that is concluded. It is inter partes. It is final. It is unchangeable unless in review or curative.
Yes.
The entire concept of stare decisis will be completely subverted, Malas.
Where is the question formulated that we should set aside a particular judgment?
Yes.
You are proceeding on the premise, we are also sitting in appellate court. We know distinction between 143.1.
Yes.
We know the scope of 143.2.
Yes.
We know Kaveri and 2G scan, the distinction drawn. We are not here on 131. We are in, within the parameters of 143.1. And the only issue is that whether the questions raised have been answered or not.
So may I answer? May I answer my last question? May I answer my last
3G, except for the 3G decision, the primary distinction between an adjudicatory decision by virtue of judgment stands on a completely different footing from that of an advisory and consistently
That's my
has
submission.
held.
That's my submission,
Therefore, only nuance that has been brought about in the 2G judgment.
which is what I'm coming to straight away. But let me just take 30 seconds to answer Justice Suryakant's query.
Touch that judgment.
So
at all.
let me answer Justice Suryakant. Malas, this is the important nuance. The nuance of 2G is that the phrase, these are not my words, the Supreme Court words. The decision cannot be changed. The view of the law may be changed. Right, Malas? No, just give me. Now let me answer Justice Suryakant's query. No, just let me answer. My Lord Justice Suryakant says to me that we will not be touching that decision. Unfortunately, Malas, this is one rare case where both the decision of the case and the view of the law fuse. Let me explain that. There is a complete intersection. Your lordships can't do one without doing the other. And if one is prohibited, the other stands prohibited. Your lordship, all the questions except the peripheral ones 11, 12, 14, if answered other than the way in which the division bench answered it, will constitute a change of law, but a change of law also in the decided case of Tamil Nadu. Because for the simple reason, your lordship's advisory law, which is binding, all admit that your lordship's
But
advisory.
argument is to accept it. Once there are judgments by court, then everything should stop at that.
No, Malas. Your lordships may find, for example, I mean, this may sound technical.
43
No,
one
that will-
definitely not binding. It is purely advisory in nature. Let's be very clear about it.
No, Malas. Your lordship's law says that once your lordship delivers judgment,
But
then it is
still,
law of the law binding. No,
by
Malas.
a larger bench.
No,
It will
Malas.
be done by a larger bench.
Once your lordship delivers 143, it's a question directly arising, I'll give the judgment.
How says that?
Your lordship's views, because your lordship is the Supreme Court, I can't seek your lordship's advice and disregard it. I can't seek your lordship's advice and disregard it.
The pre and post constitution principles are well settled.
Yes.
143.1 or a principle which was earlier to that effect, it is advisory in nature, purely advisory in nature, may or may not be accepted by.
No, Malas, that's not the law. Unfortunately, that's not the law, Malas. Unfortunately, I would say it's not the law because your lordship doesn't give advisory jurisdiction in futility.
More than 40 minutes now.
No, Malas, but
So the timelines have to be followed.
Malas,
You should have decided between you and Mr. Venugopal. That's true.
Well, it's therefore, let me just now turn to, so let me say this, your lordship's view, whatever your lordship view takes in 143 is binding. Let's be very clear on that. Second, your lordship's fellows is not, to answer the Honorable Chief Justice, this is not perennial. A matter is referred, the law will change for the future. If a matter, to give a small example, Honorable Chief Justice, remember yesterday a matter came. Suppose in an appropriate matter, your lordship refers it. A constitution bench constituted by my lord's reference in that case may decide the law ultimately. It can't be in 143. We are discussing maintainability of 143. 143 is not maintainable. Now turn to Kaveri, Malas, very quickly. Malas, Kaveri, just turn to para 37 at page 8. I'm sorry, Malas, I'm sorry. Show me the mark. Whereas Rudmalas turn to 19, para 19 at page 5429.
Of the judgment volume.
Yes, that is volume 5.14. 5.14. Well, otherwise, kindly consider the institutional implications for having advisory jurisdiction on a matter which will change the decision between parties. It becomes a pure intra-court appeal. It becomes a pure review. It becomes a pure curative.
Simply you are proceeding on assumptions.
No, in
Why
the
are you proceeding on assumptions?
no, I'm saying in the
The
event the lordship
reference will be
accepts.
answered whatever we, how do you think it's going to change the decision
No, Malas, with respect.
already rendered by the division bench? You are proceeding as if that judgment will automatically be annulled.
With respect.
That's not right.
No,
Why are you presuming on that?
No, Malas, I'm not presuming. Kindly give me.
That's how you are proceeding.
No,
You are
I am
based
saying,
on that
no,
assumption.
we are testing maintainability, Malas. We are testing maintainability, right, Malas? For maintainability,
You are relying on which judgment that it is
if
not.
I win in the merits,
Come to the point, please.
well, if I win in the merits,
Come
nothing
to the point,
yes.
you show us one judgment.
Yes.
Which says that once there is a judgment of a division bench, the reference under 143 is not tenable.
Kindly let us first see this judgment. Because we are talking about advisory. Come to para 19 at page 5429. 5429. Changes can be made, Balas, only in another matter for the future, not Balas in an existing case.
So that's the issue. We are not deciding as to whether Tamil Nadu judgment is correct or not. We are not deciding that issue.
In
We are only answering the reference made by the Precedent.
but in the event your lordship's answers are not consistent with the Tamil
Then
Nadu
we are not
matter,
concerned with
then
that.
it becomes a different matter.
We are not concerned with that. It's
Kindly-
an advisory jurisdiction.
Very well. Let me just read first Kaveri.
So that judgment which says that the reference is not tenable once there is a judgment by
Well,
2 judges or 3 judges.
Yes, yes. Let me show whatever is there very quickly. Two judgments only. Malas. Come to 19. Where Malas, the tribunal held against Tamil Nadu, the Supreme Court allowed the appeal in 19. Ignore all that. And come to Malas. Straight away para 25 where Karnataka instituted a suit. Let me come to the relevant part. Give me the relevant para. Straight away 83 Malas.
There are 83.
83.
83. Yes.
This court by its decision of April, Justice Nath has got it.
Yes.
Chandukar has got it. This court by its decision of April 26, this April 26 is para 19, my lord, the right on the side, para 19, has held as pointed out that the central government had made a reference to the tribunal for the consideration of the claim for interim relief prayed for by the state of Tamil Nadu, and hence the tribunal had jurisdiction to consider the said request being a part of the reference itself. Implicit in the said decision is the finding that the subject of interim relief is a matter connected with the relevant water dispute. Now see from here, Malas. Hence, the central government could refer the matter of granting relief for adjudication. Although this court by the said decision has kept the open the question whether the tribunal has incidental, ancillary, inherent or implied power to grant interim relief when no reference for grant of relief is made, it has in terms concluded the second part of the question. This was the earlier judgment of the Supreme Court. It has in terms concluded the second part of the question. We therefore cannot countenance a situation where question 3 and for that matter question 1 and 2 may be so construed so as to invite our opinion on the said decision of the court. That would amount to our sitting an appeal on the said decision, which is impermissible for us to do even in adjudicatory jurisdiction. Nor is it competent for the President to invest us with an appellate jurisdiction over the said decision through a reference under 143. Mr. Nariman contended, however, that the President can refer any question of law under 143 and therefore also asked this court to reconsider any of its decisions. That is a direct argument. 143 is quoted. 85. In support of his contention, he referred to Delhi laws. Next line. For the reasons which follow, we are unable to accept this contention. In the first instance, the language of 143.1, far from supporting Shri Nariman's contention, is opposed to it. The said clause empowers the President to refer for this court's opinion a question of law or fact, which has arisen or is likely to arise. When this court in its adjudicatory jurisdiction pronounces its authoritative opinion on a question of law, it cannot be said that there is any doubt about the question of law or the same is res integra, so as to require the President to know what the true position of the law on the question is. Directly on point with us. The decision of this court on a question of law is binding on all courts and authorities. Hence, under the said clause, the President can refer a question of law only when this court has not decided it. The query asked from me, Mills. Secondly, a decision given by this court can be reviewed only under 137. When further this court overrules the view of law expressed by it in an earlier case, it does not do so sitting in appeal and exercising an appellate jurisdiction over the earlier decisions. 5 judges are saying this was. It does so in exercise of its inherent power only and only in exceptional circumstances, such as when the earlier decision is A, per incurium, or is delivered in the absence of relevant or material facts, or if it is manifestly wrong and productive of public mischief. Under the Constitution, such appellate jurisdiction does not vest in this court, nor it can be vested in it by the President of 143. To accept Shri Nariman's contention would mean that the advisory jurisdiction of 143 is also an appellate jurisdiction of this court over its own decision between the same parties, and the executive has a power to ask. If such power is read, it would be a serious inroad into the independence of the judiciary, because the judiciary includes that division bench, this court, everybody. Next, 2G nuance, because that is the main thing which is alleged to have diluted it. Turn to 2G, Mills, which is at page 8123 of volume 5.21. Volume 5.21. So this is crystal clear. Some nuancing was done in a subsequent judgment. So let me place that. 5.21, page 8123. Justice D.K. Jain wrote the main judgment, Mills. There's a concurrence, but I'll only read Justice Jain.
Para 64, 65.
No, but that's correct. That's correct. But there are 1 or 2 more paras, Mills. 8157, it starts. Would my lords come to 8176? Before I sat down.
Yes.
May I invite my lords to 8176?
Yes.
The principal objection to the maintainability of the references, it's an indirect endeavor to unsettle and overturn the verdict in 2G, which is absolutely impermissible. The stand of the objectors is that 2G case is an authoritative precedent in respect to the principle or proposition of law that all natural resources are to be disposed of by public auction. Now, Mills, remember, Mills, in this case, in the Constitution bench, the only issue was whether only way of disposal is auction, because only word is important. Otherwise, it's okay. They were considering an issue not really considered by the earlier bench. At the outset, we may note that the Attorney General has more than once stated that the Government of India is not questioning the correctness of the directions in 2G case. Kindly mark this. No, learned AG is certainly not doing it here, but I mean, this is the law. This is why your lordship doesn't open a decided case. This is what Justice Suryakant is saying, we're not going into the case, but indirectly your lordship is invited to go into the case. That's the whole contention. So here in that case, the learned AG is not questioning the correctness in the 2G case,